Coming up.
The integrated child exploitation units across this country in the past month since this decision has come in is that telecommunications companies, in compliance with the Supreme Court of Canada decision, are now denying this critical information that police are using to track down and prosecute child sex offenders, child predators. Commissioner Duhem, can you provide us with some more context on the impact that this decision has had on the RCMP integrated child exploitation units in the last month?
Commissioner Kelly, are narcotics and hard drugs allowed in Canadian prisons?
No, they are not.
So then why, and do you not think it's a little bit disingenuous that there are prison needle exchanges and safe injection sites that allow for the legal consumption of narcotics in Canadian prisons?
A couple questions around the confiscation. Government calls it buyback. You can't buy something back you never owned in the first place. But in any event, the confiscation of firearms, what is the department's plan to make that happen? First question, and how do you propose it to be rolled out? Who's going to be doing it? There's a lot of ambiguity in the industry and with firearm owners, and I think with public safety, because we're not sure exactly what's happening on that front. Could you just kind of give us an update on that, if you'd be so kind, please?
Commissioner, the judge in the Bernardo case, and I'm not sure about the sentencing comments in Magnata or Williams, but I'm sure they were the same. They said that these were people who were they could not be rehabilitated. They were sadistic, and the service has its own metrics on that. And yet they are routinely transferred to medium security. Does the CSC, do you view that as a just resolution?
This guy's garage. Like and subscribe.
Mr. Lloyd, we'll go right into questions. You're up first for 5 minutes, please.
You know, kind of leading off on my last line of questioning with the minister in the last round, he said that in regards to the Bayevitz decision requiring judicial authorizations for IP addresses, that it was an unfair allegory for me to make, that it was kind of like asking for a search warrant to look in the phone book. In fact, it's actually worse than that. Because imagine a phone book where there was phone numbers listed, but there were no names listed. The only names that are being listed are the ISPs, the telecom companies that service those phone numbers, the Teluses, the Rogers, the Bells. So police are being told now that they can't even look into that phone book of those IP addresses. They can't even know who the service providers are unless they have a warrant. And the effect of this, according to frontline RCMP officers who are working in the integrated child exploitation units across this country in the past month since this decision has come in, is that telecommunications companies, in compliance with the Supreme Court of Canada decision, are now denying this critical information that police are using to track down and prosecute child sex offenders, child predators. Commissioner Duhem, can you provide us with some more context on the impact that this decision has had on the RCMP integrated child exploitation units in the last month?
So thank you for the question, Mr. Chair. And we were a little bit surprised with the decision that came by. And at this point in time, a decision was rendered 3 weeks ago. I've asked throughout the country to monitor any impacts on our operations. And I don't have the numbers just yet because it's relatively fresh. We'd be more than happy to come back to the committee. I think it's important to note that although we're focused on children, which is extremely important, I'm looking at it much broader. I'm looking at threats to elected officials, threats to individuals, and whatnot. So it's a little early. We've been through other cases like Stitchcomb. When Stitchcomb came in, we had to readjust. Our concern is just we want to make sure that there's no additional delays, and we're monitoring that right now. But I don't have the total impact right now as to the impacts on the operation.
Thank you. And a very good point that you've made is that, you know, of course, the issue of protecting children is of paramount importance. But this decision is not just impacting child predator investigations. This is about threats against elected officials. In the case of Bayevitz itself, is about a case of fraud involving stolen credit cards. This is a groundbreaking decision. And I must say it was not a clear majority, like it was a majority of the Supreme Court, but it was a 5-4 decision. And the dissenting judges, in their own words, said that this decision would, in their words, quote, seriously thwart the police's ability to investigate such serious offenses against children. They also said later down that it would exacerbate the existing challenges faced by the criminal justice system. Commissioner Duhem, we know that our police are overwhelmed with the tasks that we have given them. They're overwhelmed by the paperwork requirements that are required for them. Can you tell us what the impact is of having to get search warrants every time they get an IP address, say, from the FBI? Because we know that it's our international allies who are providing us with this information. There was a case in my own area, in the greater Edmonton area, where a mother was allegedly putting up videos of their own child. And it was because of a conviction and investigation in California that led to the procurement of those IP addresses, which were given to our integrated child exploitation units, which allowed them to rescue that child from that situation. And under this decision, those IP addresses would arguably be inadmissible in a case. This is a devastating blow for child protection in our country. Can you tell us what these paperwork requirements, these new administrative requirements, are going to do to investigations? Thank you.
So, Mr. Chair, the impact is not only felt in the RCMP, but it's also felt by my colleague, Mr. David Vigneault from CSIS. But again, the decision was rendered in 3 weeks. I don't have the number of files that took place in the last 3 weeks that incurred delays, but from an organization's perspective, we are monitoring as to what is the impact on our current operations. I think I kind of know what the impacts are, but I want some metrics to make sure that we can come forward with a proposal to the minister as we move forward.
Commissioner Duhem, I'm just wondering if you could commit to table the number of cases that might be affected by the Bykovitz decision. Is that something you'd be able to take back and table to this committee?
Mr. President, I can commit we'll look into it, but I'm just not quite sure if we have it. So
No, I appreciate that. Thank you very much. Commissioner Kelly, are narcotics and hard drugs allowed in Canadian prisons?
No, they are not.
So then why, and do you not think it's a little bit disingenuous that there are prison needle exchanges and safe injection sites that allow for the legal consumption of narcotics in Canadian prisons?
So these are harm reduction programs that have been implemented. In terms of the prison needle exchange program,
So Commissioner Kelly, you stated that narcotics are not allowed in our prisons. Yet there is programs that facilitate their legal use in our prisons. I think Canadians are rightfully disappointed, and quite frankly, I hear from many that are disgusted that would be something and the official policy of the Correctional Service of Canada. But I think further to that, Commissioner, do the guards that are responsible for ensuring that inmates are safe and ensuring that the Canadian public are safe, do guards, the correctional service officers of this country, support those programs and their use in our prisons?
So in terms of the prison needle...
So do guards, do officers support these programs? And they're the ones that are on the front lines of facing the consequences of these programs. Do they support those programs in our prisons?
I would say that some, yes, do support it. I would say that the prison needle exchange program is more challenging, and there's more support for the overdose prevention service.
So it's interesting because when it comes to, and I've tabled a petition in the House of Commons from correctional officers, and I've spoken to many correctional officers, and I'm proud to represent Battle River Crowfoot, of which is home to a federal institution, and many of my constituents are in fact correctional officers. And so far, I have yet to find an officer that supports the administration and allowance of illegal narcotics in Canadian prisons. Madam Commissioner, when it comes to stopping the flow of narcotics, do you think an environmental assessment of netting over a prison or some of the other tools that could actually deal with things like drones but getting held up in the bureaucracy, do you think that's an acceptable excuse to slow down the approval of things that would actually stop the flow of illegal drugs into our prisons?
Actually, we've done an awful lot. Drones are definitely an issue.
A huge issue, yes.
Yes, and there's been an increase in the last year of 37%. Since 2020, it's been an increase of 104%.
Yeah.
And we have a different measures that we use, intelligence, searches, but also we have drone detection systems.
But I do
Chair,
hear
point of
again
order.
from...
Chair, I understand Mr. Kirk loves the sound of his own voice, but I would actually love to hear the answer from Commissioner Kelly on any of his questions.
Okay, let's continue, Mr. Carrick, please.
Thank you, and I'm sorry that Ms. O'Connell is so offended by some of the questions that I'm asking on behalf of prison guards in our country. So Commissioner Kelly, the challenge associated with some of these things is that there is there's been a staggering decline in morale within the correctional service. There has been a host of concerns. There's not trust within the Ombudsman's office. So my question is simple, and I hope to get a quick one to the parole board here as well. But will you commit to speaking with your officers on the ground to actually hear the concerns that they have within the service?
What I can say is, in the last few days, I've visited 3 institutions, and every time I visit an institution, I speak to the union's representatives, and I gather their comments.
So some unsolicited advice is speak to some of the guards on the ground, Commissioner Kelly, because I can tell you the conversations that I have, there is a troubling lack of confidence and a growing decline in morale within your service that is ultimately impacting the public safety of not only those officers, but also the trust that Canadians need to have in their institutions. Thank you.
Chair, my questions today are going to be focused more to Ms. Geddes, specific to firearms. Now, I know that back in 2019, the minister of the day and internal documents have shown that the government has estimated the confiscation of the firearms will be 400 to 600 million. We know that that is probably 3 times less than what it actually will be. Conservative estimates, small c conservative estimates from across the industry put it at over $2 billion. So a couple questions around the confiscation. Government calls it buyback. You can't buy something back you never owned in the first place. But in any event, the confiscation of firearms, what is the department's plan to make that happen? First question. And how do you propose it to be rolled out? Who's going to be doing it? There's a lot of ambiguity in the industry and with firearm owners, and I think with public safety, because we're not sure exactly what's happening on that front. Could you just kind of give us an update on that, if you'd be so kind, please?
Thank you very much for the question. First of all, at Public Safety, we certainly are framing it as a firearm compensation program. As you pointed out, an extremely complex program to be able to deliver. Some of the data has indeed been difficult to obtain. We're working as closely as we can with business and industry who have access to the best possible data. We're working with chief firearms officers across the country as well to try to do our best to be able to get a good estimate of the number of firearms that we will be looking at compensation. In terms of the program development itself, as the minister spoke to, we're looking at doing this in 2 phases. So first, to be able to look at how we collect from business and industry, and in the process of doing so, to be able to learn from that about the most cost-effective, the most efficient, and the way in which to ensure the safety of Canadians in the way in which we deliver on this program. So first phase being business and industry, and the second phase being to reach out to individuals who are currently protected under the amnesty order. So we're doing it in a very careful, conscientious way. As I said, kind of got it by those 3 principles about efficiency for dollars for Canadians, doing this in a very cost-effective way, but also, as I said, making sure that we are prioritizing public safety throughout the execution of the program.
Okay, I'm going to get to the amnesty issue in a minute. You know, what I find troubling is that the evidence that law enforcement has shown across the country is that this, you know, you're the wrong person to ask, but I'm going to make the statement anyway, Ms. Geddes, that the confiscation of these firearms will do nothing to improve public safety in this country. Absolutely nothing. In fact, gun crimes continue to go up even during this amnesty program, and not by firearms owners. So I guess what I'm concerned about is the law enforcement community has pushed back on government and has voiced their concern and their opposition to being the ones responsible to confiscate these firearms, including the RCMP. I'm just wondering, you can go to industry and ask them to voluntarily surrender the firearms that fall under this prohibition, voluntarily with compensation, which I hope will be appropriate, except the taxpayers are going to be on the hook for it. But how are you going to deal with individuals? Who's going to collect the firearms from individuals who resist this policy, not because they are criminals, but we've made administrative criminals out of people without committing a criminal act. And I'm just kind of concerned about that. And I want to get to another question that it's in line with it, so together. So the government has introduced legislation to, some proposed legislation and changes to the Elections Act. One of them being the election might take place later in October, like October the 27th of 2025. So has there been any thought to the impact changes to the Elections Act will have on the amnesty period, which goes till October 25 of 2025? And the impact, we will have no government sitting at that point in time. Is there some provisions going to be in place to make that work and how that's going to look moving forward?
Thank you for your question. So I'll try to answer both of those together. I do want to acknowledge your point. Gun crime in this country is extremely complex, and finding ways in which to be able to address it. There's not one simple method, one simple program that is going to address gun crime completely. There's a comprehensive approach that we are putting in place, whether it's dealing with communities directly through investments, the Building Safer Communities funds, investments in support to the RCMP and to CBSA to be able to address some of those challenges. So the firearms compensation program is certainly one part of a broader and more comprehensive program to be able to address gun crime in the country. I'll ask Commissioner Duham if he wants to add anything about the law enforcement aspects of gun crime. But on your second question around the amnesty order, as we are designing the program, and we are doing it, as I said, adhering to those principles, including how we prioritize public safety, which I think is partly your question, is how do we make sure that Canadians are safe throughout this program? So that is one of the most kind of compelling features of the program design, certainly. We are providing advice to government on how we intend to implement this, including how best to be able to meet the dates of the amnesty order as they're set out. So we will continue to provide that advice to government.
Thank you, Mr. Motts. We're moving over to the Liberals now. Excuse me. Ms. O'Connell, please.
Commissioner, the judge in the Bernardo case, and I'm not sure about the sentencing comments in Magnotta or Williams, but I'm sure they were the same. They said that these were people who were they could not be rehabilitated. They were sadistic, and the service has its own metrics on that. And yet they are routinely transferred to medium security. Does the CSC, do you view that as a just resolution?
So again, we have a rigorous process in place to assess the security classification of offenders, and I would say they are appropriately placed. I would also say that in maximum security, over 95% of the inmates that are there because they are a threat to the staff, they are a threat to the institution, and they are a threat to other inmates. That's who is in our maximum security institutions.
So just so I'm clear from what you said, you view it as appropriate that the likes of Magnotta, Bernardo, Williams, whomever, are appropriately held at maximum security. That is a just outcome given what their victims have gone through?
Obviously, my hearts go out to the victims whose lives have been changed forever by the heinous crimes that have been committed by these individuals. But again, we have a rigorous security classification process. In the Bernardo case, as you know, we did a full review. We did actually 2 reviews. And in the end, the reviews concluded that we had respected the laws and the policies.
Well, of course, and I mean, those laws we know who instituted those laws and those policies. So yes, the laws were followed. They just led to an unjust result.
Mr. Caputo, your time's up, please. Ms. O'Connell for 2 minutes.
Thank you, Chair. Following up to Commissioner Kelly on that very point, when it comes to, you've made this point before, but for some reason, I guess conservatives don't want to be confused by the facts. But in terms of sentencing and the facilities themselves are not connected to sentences themselves. It's in and around the organization of the prison itself. And you identified that maximum security prisoners pose a threat to the safety of the correctional workers, to other inmates, but that where prisoners are held are not conditioned to sentencing. It's a condition of the corrections being able to control and contain and keep the public safe. Is that correct?
That's right. So when offenders come to us, we have a responsibility, like I said, to make an assessment on their security classification and ensure they are transferred to the appropriate institution based on a series of factors. So once we've assessed them, then we have to determine which institution is the best to meet the security requirements, interventions that are required, programs that are required.
And if it was truly a continuation of sentencing, wouldn't a former prosecutor know that sentencing and those decisions at the courts and what the prosecution can even ask for don't include facilities because it is strict? It is not a continuation of punishment. The punishment is the sentence itself, and
That's right.
this individual being removed from the community, and that is why it is left up to correctionals experts of how to take that individual and properly secure them away from the public and properly keep correctional service officers safe.
That's right. We administer the sentences imposed by the courts.
Thank you.
Thank you. Thank you, Ms. O'Connell.